Court is now in session.
Thank you all. Please be seated. Good morning. This is a time set for oral argument in Judd versus Stockwell, our case number CV16-0426. Each side is allocated 20 minutes for argument. Appellant may reserve a portion of that time for rebuttal. If you wish to do so, you need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask those in attendance to make sure that your cell phones are off so our discussion is not interrupted. We have reviewed the briefs. We've conferenced the case. We're familiar with the record. We'd encourage you to keep that in mind as you present oral argument today. Our proceedings are being recorded, so please, as you approach the microphone, tell us your name and the party that you represent. The recordings will be posted to our website and then onto YouTube in due course as well. With that, Mr. McQueen, you may begin.
Good morning. I'd like to set aside about 5 minutes for some rebuttal time, so to answer some follow-up questions or anything like that. Patrick McQueen, on behalf of the appellant Kelly Judd in this matter, we're asking for 4 different things. We're trying to raise 4 different points here. First thing we're asking for this morning is a finding that there was sufficient evidence that existed, that duress in this matter existed. We believe that there was sufficient evidence of duress, and the trial court simply missed that issue. The second finding we're requesting is that there be a determination that there's a question of fact as to the parties to the release. The third thing we wanted to raise today is that there's a question of fact as to post-release conversion. And the fourth matter that we're going to address today, or hope to address today, is that this matter did not arise out of the release. It arose out of pre-release behavior. Now, as to the issue of duress, duress is typically a matter of fact. A typical duress claim involves an ultimatum. There's a threat to somebody physically or financially, and that threat is wrongful. And we've seen an evolution of case law throughout the United States that has shown initial duress cases involving a threat to the physical well-being of a person into duress being related to economic and business coercion.
Well, it seems like there's no evidence here of a physical threat. So what is the evidence of financial duress, recognizing that? Well, why don't you tell me? I won't characterize it.
Sure. So I agree that there was no physical threat here. That's absolutely conceded. She made no threat. The trial court found no threat. But that's not what we're trying to get at. Our point is that an ultimatum is not always required. Under the Intertel decision, there was no ultimatum here, or made there. There was no ultimatum here either. Under the Intertel decision, if you financially decimate somebody or do things to financially harm them, and those actions are wrongful, then you can have duress as well. So yes, I agree. There's no physical threat here. We've got no evidence of a physical threat or a threat to put him into bankruptcy. It was her sort of degradation of his credit, of his finances, of his savings, and his legal position that led to the release here. So again, a typical case involving duress is a threat to somebody's financial wherewithal, and that threat being wrongful. That's how the trial court ruled. She said there was no threat, and it wasn't wrongful. I mean, if you look at the minute entry, she says, there's no evidence that defendants made any threats against plaintiff or engaged in any improper conduct. But again, as I just mentioned, an ultimatum is not always required. Duress exists if a perpetrator degrades the finances of somebody else under Intertel, and that is wrongful, and that the actions are wrongful. Here, we alleged, and there's evidence, that there was a systematic degradation that began when Ms. Stockwell no longer wanted to be with Mr. Judd. That began with her asking him to convey property to her as her sole and separate property that they previously jointly owned, with the promise that she would turn around and reconvey it to them as with survivorship rights. That never happened. Then she goes and fires him from the business that he believed he was a partner in or had some sort of employment relationship in. Then she goes and takes his files, and then she ultimately takes his personal property, leaving him with no other alternative except the $20,000 and move on and try to get back on his feet. And so if you look at those sort of factors, we have a systematic degradation of his financial wherewithal, which ultimately led to him signing that release. And that's exactly what happened in Intertel. In the Intertel decision, the Bank of America put Intertel into a collection account for no apparent reason. And this affected their ability to function, their ability to get credit. And then they said, well, release me from that release us from improperly doing that. And that's exactly what happened here.
I'm struggling to see the financial degradation here. In my understanding, your client had another job lined up, in fact, started it in close proximity to these events.
He did. He had another job lined up, but I don't know that he didn't have a salary. It was a real estate matter, so he would have been entitled to commissions. But he did have a job lined up pretty shortly thereafter, but he didn't have money coming in. And so,
wasn't the evidence also that the defendant here offered him $9,000 to help him purchase a vehicle?
There was evidence of that as well, Your Honor. Absolutely. So,
doesn't duress presume that the reality is that your client in this situation has no choice?
I think that's a question of fact. I do. And if you look at the Intertel decision, and I'd like to actually read a portion of the Intertel decision, the fact that he has or does not have an alternative is a question of fact. And if you look at the Intertel decision, I'm trying to find the page number here. Well, it's paragraph 42. It basically says the fact that some months later Intertel did not find other financing does not conclusively establish that Intertel had a reasonable alternative when it signed the release. So the fact that he had all their alternatives, that's great, but I don't think it's the end-all, be-all. The other thing that we have to remember, Your Honor, is that she admitted after the release was signed that she thought he had no wherewithal. She said it was a mystery how he could function after he signed the release. So if he couldn't function, if she didn't think if it was a mystery as to how he could function after signing the release, it was only a matter of it must have been worse prior to signing the release. So she's sort of shot herself in the foot with that evidence, saying I knew he was in such dire straits, and I knew it even after he signed the release.
Isn't that extrapolating quite a bit from that statement?
I don't believe it is, Your Honor, because she was monitoring his accounts. She knew exactly what was going on, and she knew the exact time to do this. So I think based on her behavior, it's not a stretch to believe that her post-release comments meant that he didn't really have much prior to signing the release.
And help me out, though, if your position is right on duress, when would a release ever be enforceable if the parties were in dissimilar financial positions?
When would a release be effective? If you have, well, whenever you have bargaining power that's at least somewhat similar.
No, and I'm saying it's bargaining power is dissimilar. Isn't your theory that when bargaining power is dissimilar, a release can never be enforceable?
When you have a situation that the perpetrator leads the person who's signing the release into this financial conundrum, that's when they're ineffective. Is our point. So it's completely dependent upon the facts, and I think that's what the opinions have shown thus far, is that it's an issue of fact as to whether certain circumstances constitute duress. And
let me understand then, with your position, when would the issue of duress ever be resolvable on motion? Or are you saying it can't be?
I'm saying I think it can be. I do think it can be, and I think there is a case that says it can be resolved as a matter of a law when certain circumstances absolutely do not constitute duress, when you don't plead that there's a wrongful action or there wasn't a wrongful action. There were some cases prior to the Intertel decision in which courts ruled as a matter of law, but those cases basically said there was no wrongful action here because there was just hard bargaining. Those weren't situations where the perpetrator degraded somebody else's finances to such an extent that he had no alternative design.
And I guess what I'm looking for is what bound would there be? Because if your argument is, well, this is an issue of fact, and this is not exactly your language, but because they're dissimilar positions and bargaining positions, when would any contract of any type not be subject to a disputed issue of material fact that would require a trial if any claim of duress is ever raised?
I think what Your Honor is saying is that there's a concern that, if you rule in our favor in this instance, that there's the possibility of this endless cases coming out where somebody says, hey, we've got a situation of duress here. I didn't mean to sign this contract.
It's a little different than that. It is to compare that hypothetical, admittedly, with what I think the cases say, and I don't think the cases support that hypothetical.
Well, I guess my point to your question is we've got safeguards in place under Arizona law, ARS 12349, ARS 1234101, Rule 11, that guard against frivolous types of situations, and so that's how I would answer that. Now, let me just move on very quickly. If you notice, the appellees in this matter are shying away from this Intertel decision. They're basically arguing for this new set of standards that was never raised at the trial court level. They're basically saying that Mr. Judd had to suffer some sort of grievous economic loss, and that there's a distinction between personal economic duress and business economic duress. Number one, they never argued that at the trial court. Number two, the cases that they've used at the trial court, if there is a distinction between personal economic duress and business economic duress, they use the business economic duress. So they clearly think that this is related to a business matter. Additionally, there is no case law aside from this Pleasance case that they've cited to that distinguishes between, or that makes grievous economic loss a standard here. So I don't know where this. I think what they're trying to do is shift away from Intertel, because there's some harmful language in that case, and it's very analogous to what we have here, into saying that there's this new standard and there's a distinction between personal economic duress and business economic duress, when in fact there really is no distinction. So I wanted to make that point. Additionally, if grievous economic loss is the standard, our client could barely function. He had credit card debt because of her promises to pay him back. He had no home because of her. She took his interest in the property without returning that interest. He had no job because of her. He had no personal property because of her, and he had no access to his files. He couldn't even determine whether the $20,000 was a fair result because she wouldn't give him access to the files that he created. She admitted to all of this. She knew that she admitted to monitoring his banking, and again, even after the release, she said it was a mystery how he's able to function after the release. So I think those factors sort of support that even if grievous economic loss is a standard and there is a distinction between personal economic duress and business economic duress, I still think we satisfy that. Now, moving on, and so again, we believe at a minimum, we're not here to discuss or to make a determination that duress did or did not happen here. We believe that under these circumstances, a reasonable fact finder, a reasonable juror could find for duress. We're not here to say it occurred or it did not occur. And remember, that's what we're here to determine, whether somebody could find that duress existed, and we believe that's the case here. Now, moving on to the parties to the release, again, under the Hamada decision, whenever you have a choice between two words or two meanings, a court cannot decide the issue, what that term meant on summary judgment. In the Hamada decision, we had the word loan that could have meant multiple things, and the Court of Appeals said, yes, because it could have meant multiple things, we cannot decide this on summary judgment. Same thing here. Business relationship could have meant multiple things. Yes, he had a business relationship with BLRE, but they also treated much of their personal lives in a business-like manner. She agreed and acknowledged that they were splitting costs. She agreed and acknowledged that they were crediting each other for various payments. The parties were not married, so they had to treat it somewhat as a business. So I wanted to point that out because, again, under the Hamada decision, this is almost an analogous situation where the reference to the word loan in ordinary meaning means a loan, but it could mean multiple things to multiple people, just like business relationship here meant something to him and it meant something to her. And so I don't think that issue could have been resolved on summary judgment. As to the conversion, respectfully, we believe that the trial court just simply missed this issue. She's admitted to not returning everything in their pleading papers. They've said she's returned 99% of items, et cetera. The trial court said that all of the claims, including the conversion, arose prior to the release, and that's just not true. The conversion claim is that she still has not returned his items of personal property. I don't know how you dispute that. They've come up with an argument that says, well, he waived the right to ask for a conversion or bring a conversion claim because she provided unimpeded entry. Well, she provided unimpeded entry, we'll acknowledge that, but then after she provided whatever entry she provided, she acknowledged that there were still items of personal property that were missing. So I think that the trial court respectfully just missed that issue. And I'll be quick. I'll argue that under the attorney's fees issue, yes, Mr. Judd seeks to invalidate the release. There's no doubt about that. But the release was the end event here. The gist of this lawsuit was her pre-release behavior. Okay, that's under the Ash and Lamb decisions. This case is not about the release; it's about her pre-release behavior.
Counsel, let me ask you just one question
Sure.
on that point. What are we to make of your client's allegations, perhaps a dozen times or close, in the operative pleadings that this is a case that arises out of contract under 12-340-101?
I'm sorry, could you repeat that?
Sure. Your client's operative pleading alleges about a dozen times that fees are proper under 12-340-101. You're now arguing that fees are not proper under 12-340-101. How do we rectify that?
There are certain claims that arose out of contract in this matter. He alleged breach of contract, but I think that the gist here is her pre-release behavior, her pre-release promises. So it is a mixed bag of contract and tort claims here, but I think that the underlying issue is the fraud that she committed on him, or the alleged fraud that she committed on him in getting him to sign that release. Thank you.
Thank you. Mr. Jacob.
Good morning. Andy Jacob, representing Pelley Stockwell. I think the issue here is, why was Mr. Judd cash poor on July 18th? I think his argument is that he was so cash poor he had no alternative but to accept the $20,000, even though he didn't think he should be bound by a contract that he made. He was cash poor because he made himself cash poor. All the things that are complained about against my client, had she not done them, he still would have been cash poor. Had she recognized that he had $1 million interest in her company, he would have been cash poor, because there's no allegation that she agreed to buy him out the day that they would split. If he still had an interest in the house, and we don't know that there was any equity value in the house, if he still had that interest, he wouldn't have had cash. He made himself in this situation. He chose for years to not work for wages. He didn't get wages for whatever work he did for BLRE. He didn't go out and get any other job. This was not imposed upon him. Unlike some of the other cases that we cite, he wasn't promised that if they split up, she would give him cash to take care of him, and then when they split up, she says, but I'm only going to give you this, or you're not going to get anything. Those facts aren't here. I would also ask the court to be careful on the facts that counsel just told the court. Counsel did not cite to the record properly. I would contest a lot of the facts that he just said. My client did not concede that she's holding on to Mr. Judd's property. The parties here clearly intended to put an end to things. Mr. Judd added, I want to be able to get my property back. Ms. Stockwell said, fine. She let him go into the house. She let him take as much time as he wanted to take. There's no evidence that she impeded that in any way. She's not saying, yes, I have your property and I'm not going to give it back to you. He had the opportunity to take everything. He now says he's missing things. He doesn't say she has them. What he says is, I want a second look. The release did not give him the right to a first look. She gave him that, and he took it, and they're through. And she's happy to give him back anything that she might have. She hasn't said that she has
What about
anything of his.
the allegation that your client extracted a quitclaim deed in return for a promise that a new deed would be created with a right of survivorship?
One could argue that was tricky, that was wrong. And she settled a claim for that. And had she not done that, he would have still been cash poor on July 18th and would have been in the same situation, that he would have taken the $20,000 under the same circumstance, because the circumstance was not caused by the change in the deed. The circumstance was caused by the fact that he chose to live off of her income. He did not earn any money himself. There's no allegation, there's no evidence that she prevented him from working on his own.
Are we supposed to be able to tell from the record that the $20,000 represented an interest in the real property as opposed to something else?
We don't know. It settled all of the claims that he would have against her. If you reject the economic duress, he's lost that claim that what she did with the deed was wrong. If he felt that he didn't have any option but to take the $20,000, and I argue that he did have other options, that's his doing, not hers. An economic duress requires that the situation that deprives him of free will is caused by the defendant on the economic claim. And in this case, his situation that deprived him of free will, which was being cash poor, it wasn't not having an equity interest in her business, not having an equity interest in her home, because even if he had those, he wouldn't have had cash in his pocket to buy food, buy a car, pay rent, whatever things he felt forced him to take this offer. The case law also
Let me ask you, your point, if I'm hearing it right, is if these two parties were strangers and they reached an agreement like this, that there's no claim of duress that could ever be made? Is that, if I hear you right, you're arguing that the defendant had to place the party claiming duress into a vulnerable position, and I don't read the cases that way.
The case law is to have this situation be parallel to the case law. My client would have had to have promised Mr. Judd over the years, if we ever split up, I'll take care of you. I'll see to it that you're able to get by. I'll give you cash if we split up. I'll buy you a car. I'll rent you an apartment. If she made promises like that, and that was why he allowed himself to be cash poor. And then when the day comes, she says, I'm only going to give you $20,000, take it or leave it. he would have a claim. But those aren't the facts here. He does not say that she ever made any promises to him. He allowed himself to be vulnerable. It was not her doing that he didn't work for cash. He chose that. He could have told her, no, I don't want an equity interest. If I'm going to work for your company, I want to be paid for it. And at one point, she did pay him $22,000.
So to the extent the cases in duress focus on exploiting a vulnerability as opposed to who is responsible for a party being vulnerable, you would disagree with those. Is that what I hear? In other words, does it really matter why or how he became cash poor or who caused that?
Yes, it does.
Okay.
And
And what's the best case for that proposition?
well, the best case for that is a Massachusetts case that was cited favorably in support of the Intertel case. And that's a case where a contractor,
Can I ask, are you aware of Arizona cases finding that or holding that?
well, the Intertel case, the bank put the borrower in a situation where the borrower couldn't get refinancing anywhere else. And then the bank gave them a take it or leave it offer. The borrower didn't say, I'm okay with you putting me into that situation. I'm just going to let it happen. What we have here is Mr. Judd saw what was going on. He saw that he was borrowing from his mother. He saw he was maxing out his credit cards, and he didn't work for wages. He saw that his bank account didn't have anything in it. He could have gone out of the home and gotten himself a job to earn money. He didn't do that. He had no reason to rely on my client to give him cash if he was to leave her home. He does not say that she made any promise to him to make things right. And she didn't make any promise to him. There's an issue of fact whether she told him to leave or whether he left on his own, but he allowed himself to be in that situation where if he did leave, he wouldn't have any money. And yes, she's allowed, if he leaves himself in that situation, to make him an offer that perhaps he has to take. Now, I don't know that he had to take it. I don't know that he faced the equivalent of a company facing bankruptcy if it didn't take the offer. That's the equivalent of what a person would have to face. We don't have to decide that because he created his situation. He knew it was happening. He chose to rely on her to support him. And having done so, he found himself, when she says, I'm done with this, he didn't have any money. And like I said, if all the wrongdoing that we might attribute to her, the fact that she changed the deed, if he still had a deed in the house, still had co-tenancy in the house, there's no evidence that he could have extracted any cash from that. There was already a mortgage on the house. If he had ownership in BLRE, there's no evidence that he could have compelled her to buy him out for a certain dollar figure, he still would have been in a situation where she would have said, I'm offering you X dollars for it. And if he took it, can he turn around and say, well, now I'm going to sue you for more? No, because he created that situation. He let it happen, not her. A couple of other comments. The release applies to a business relationship. The common meaning of a business, it's an interaction with third parties. The interaction between two people that doesn't involve third parties, paying household expenses and things, keeping track of the books, that's not a business, that's business-like. The only business involved between these two parties was BLRE. We contend, therefore, that the release applies to claims against that entity. If it doesn't, the only claims against the entity are the wage claims. Any claim for compensation due to an equity interest in BLRE is a claim against the other owner of BLRE because she has to give him her ownership interest. It's not a claim against the entity. We explained in our brief why the wage claim, if it's not subject to the release, is not a valid claim. First off, he believes he was a partner in BLRE, and when partners work for the company, there's not a presumption that they're entitled to a wage. It's just the opposite. If he was an employee of BLRE as a partner, his own evidence goes against that. He says he wasn't. There wasn't an employee relationship. There was no history of being paid a wage. There was no contract for wages. So whether the release applies to BLRE or not, we think that claim is also invalid and should have been dismissed at summary judgment. As far as attorney fees on an economic duress claim, we have the U.S. Life v. Gutkin case, which was an economic duress claim where the court did award attorney's fees. And that case also stresses that the situation wrongfully caused by the defendant on the economic duress claim had to have been so severe as to have precluded the plaintiff's exercise of free will. And by that, they mean there was no reasonable alternative but to accept the offer. And as the court recognized today, Mr. Judd had other options. He was staying with a friend. He was offered $9,000 without strings attached to it. He had a realtor license. He had a job with a real estate firm. He wouldn't, there's no evidence that he would have been in the street in rags if he didn't accept this offer. Does the court have any other questions?
Mr. Jacob, I have some questions about the conversion claim. In looking at Judge Mullins's minute entry in granting summary judgment, she stated that Mr. Judd's claims are predicated on acts preceding the release, but Mr. Judd's claim, I believe, and you can correct me if I'm wrong, please, that his claims for conversion happened after the release was signed. So didn't Judge Mullins miss this one, I think, as appellant's counsel stated?
I don't think so. I think the claim is misstated as a conversion claim. I think it's a breach of contract claim. any property that was held without his consent on July 18th would be covered by the release of all claims. But that contract gave him the right to have her return his property to him. So her failure to do that is a breach of contract claim. He had the right to stand on the curb and say, you bring my stuff out, and if she didn't bring something out, he could say, you haven't brought everything out. But she offered him, well, you go in and you take everything. And he didn't say, no, that's your responsibility. You said you would do it. He said, okay. He went in with two friends. There's no evidence that she impeded him in any way. She allowed him to look all through the house, take everything he wants, and now he's claiming that he didn't do an adequate job. But he accepted that responsibility, and our argument is he waived the right to demand that she return his property because she let him go in. Alternatively, he accepted the agency to do her obligation for her. And now he's complaining that he breached his duty to her by failing to properly return his property to himself. And as a matter of equity, he ought not to be allowed to make that claim. My client is not saying that she wants to keep any of his property. He's not saying that she is keeping any of his property. He's just saying some of his things are missing. Well, I'll tell you, some of my things are missing also. All of us are missing things. You just think you have something, you don't have it, you forgot what happened to it. There has to be an end to this. The release was intended to put an end to it. There was an exception for her to give him his property. We believe she adequately fulfilled her obligation on that, and it should be case closed.
Thank you, Counsel.
Thank you.
Mr. McQueen, rebuttal.
Thank you, Mr. Jacob. Thank you. A couple of things that Mr. Jacob said. Number one, he essentially initially argued that there was no wrongful behavior, and then when Your Honor asked about the deed, he essentially conceded that that was potentially a wrongful behavior. The other thing, too, is if there was no wrongful behavior, I'm not quite sure why she would even ask for a release. What would he need a release for? What would she need a release for unless there was some concern over improper behavior? The other point that Mr. Jacob was trying to make, or did make, was that he was trying to blame Mr. Judd for all of this. And he was saying, well, Mr. Judd put himself in a cash poor position. Well, it wasn't just cash poor that we're talking about here. We're talking about property poor. He didn't have his interest that he could partition, that he could do anything with, that he could even live in anymore because she had taken that away on something that he just conceded was wrongful. He was personal property poor because up until that release, she was holding those items hostage, so he had no personal property. He was legally poor because he couldn't partition certain things. He was document poor because he had no access to the documents that he created for this business and could not go out and get these items and get these new clients because she had shut him down from that. He also made the point, or attempted to make the point, that Mr. Judd put himself in a vulnerable position. Well, and he had no reason to rely on anything that she said. Well, I disagree. They were lovers for 12 years. There's some intimacies that are shared in 12 years of relationship, I would argue. And so, for her to say that she was unaware of his vulnerabilities after 12 years, I think that's a convenient argument. She encouraged him to do all of these things. She encouraged him to help build up this business, and she pushed him to do it. And so, if there was a vulnerable position, it was because she was leading him down that path. And the issue of who made it happen, who put who in a vulnerable position, that's an issue of fact. I don't see how the court can rule as a matter of law as to who put who in a cash poor position. I think that's clearly an issue of fact. And I want to make a point that this isn't a case of unfair bargaining power. She was the one who put him in that unfair position. And that's kind of what I think you were asking me earlier, Judge, is where do we draw the line? It's where we draw the line where it's evident that somebody else put that person in the position. Mr. Jacob essentially conceded that there is at least some sort of conversion claim, whether it's misstated as a breach of contract claim or there are multiple theories of breach of contract that were alleged in the verified complaint. And so, he's essentially acknowledged that there's a possibility. I mean, Mr. Judd filed a verified complaint saying these are the items that are still missing. And in one of their pleadings, they said 99% of everything has been returned. Well, again, it hasn't. And it was not waived. If it was waived once, and then when she conceded that it sort of reopened the waiver argument. The final point is that we incorrectly cited to the record. I don't think that's even an issue. There was a mistake, and it was corrected in the reply brief, but it had no effect on their ability to respond to our appellate briefs. Thank you.
Thank you, counsel. We appreciate your argument. We appreciate your briefs. We will take the matter under advisement. We'll issue a written ruling in due course. We stand in recess pending the next oral argument.